evening and welcome to the Monday, October 18th meeting of the Currituck County Board of Commissioners. I would ask everyone to please stand while Reverend David Coxon leads us in the invocation and then the Pledge of Allegiance.
Let's pray together. Most gracious God and Father, sustainer and creator of this universe and this wonderful place we call home. Father in heaven, we're thankful for who you are. And Father, for your wisdom and guidance in this world. And now, Father, this evening we're thankful for the opportunity that we have to take part in this gathering, the opportunity to be a part of such a wonderful community. And Lord, this evening we pray a special blessing upon our commissioners in this meeting. Father, those whom we have placed in office, we give them our trust, and we're thankful, Father, for the discernment and the wisdom that they will show this evening. We ask that every decision made would lead us back to the center of your will. And Father, for those here this evening who provide wise counsel to them in any way, Lord, we just ask that you would be with them, give them total recall if they have something to say, that you would provide, Lord, the wisdom that they might say it well. And Father, this evening too, we just ask a special blessing upon the season. We know that, Father, next month will be a time where Americans can go to the polls. And Father, we can exercise our rights to vote and to choose and to elect officials to lead us. And Father, I pray that we do so with a discerning heart, that those whom we choose might also discern well while they are in office. And Father, we're thankful tonight for the occasion of this gathering, for every citizen of Currituck County who may be a part of this assembly. Lord, may, Father, you be with those who have agendas to present tonight, that they might speak with clarity and that fairness and justice might prevail. And Father, this evening we do ask a special blessing on all that is said and done. May it be done according to your wisdom and glory. And now unto him who is able to do immeasurably more than we could ever ask for or imagine. Father, we're thankful so much for your presence, and it's in your name we pray. Amen. Amen. Let's pledge the flag. I pledge allegiance to the flag of the United States of America and to the republic which stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Item 1 is approval of agenda. We have no additions or deletions that I'm aware of. Does staff have anything to add or delete?
Yes, sir.
All right, we need a motion for approval.
So moved.
Second.
A motion and a second. All those in favor signify by saying aye.
Aye.
Opposed, like sign. Item 2 is public comment. We have 2 people signed up to speak tonight. We ask that you observe our 3-minute time limit and that you state your name and address for the record. And at this time, we'll call Teresa McPherson.
Good evening. My name is Teresa McPherson. I live at 117 Evans Drive in Grandy. And I'm here by your advice to remind you about the Walnut Island Community Pride Days. And I have to start by saying thank you. And I mean that with all my heart. The support that the county is providing to us has enabled us to do something that we might not have otherwise been able to do. And our event begins on Thursday and runs through Saturday. Sign up if anyone would like to join in. Would be run from 7:30 in the morning through 3 in the afternoon for sign up. The event actually, cleanup takes place between 8 and 6 p.m. And we are offering a meal to all of our volunteers who come out to help, and appreciation for their hard work and effort. The support that we are receiving throughout the community is fantastic. I am so proud of Walnut Island and its residents. They have come together in a way that was more than I could ever have hoped for. And not only is this event going to be successful, it's already begun. It's been going on for about a week and a half. The cleanup throughout the island is just exceptional. And so we are very excited about what this means to our community. And so we thank you for your support and ask that you would continue to support us in this effort. We recognize that this will be ongoing. As I mentioned the last time I was here before you, that to create the enthusiasm is one thing, but to sustain the enthusiasm is the challenge. And so that's where we are. And I look forward to continued support. I do want to thank many of our private citizens for their donations. They have been just phenomenal in supporting us. As you can imagine, economic times are difficult for our businesses, our local businesses, and they're struggling and they're not able to reach out and support us in quite the way we had hoped, but that's okay. We know that everything that we have is coming from the Lord. In fact, our churches are another great source of support in our community, and we are very blessed by all of their efforts. So I'm just going to pass this out, if I may. Mr. Scanlon, if you pass that around. This is a poster that you may see around the community, just giving details of our event. And I invite anybody who would like to come out. We can use all the help that we can get. So thank you very much.
And the proclamation will be approved under item 4 tonight, so we'll officially move on that tonight.
I appreciate that. Thank you so much.
Thank you. Next is Troy Breathwaite.
Good evening. My name is Troy Breathwaite. I live at 189 Providence Drive in Moyock. I'm here tonight representing the Currituck and Camden citizens against the OLF. For those who don't know what that means, that's the outlying landing field. What I would like to do first is I really want to thank each of you commissioners for your steadfast support on this. I mean, we've been under this study for the OLF for going on 3 years now, and you all have been right there with us, and we couldn't continue to continue the way we are without your support. And so it starts with you. I'd also like to thank our elected officials at the state and federal level, Senators Byrne Hagan, Congressman Walter Jones, G.K. Butterfield, State Senator Mark Bassnight, State Representative Bill Owens, Governor Perdue. All these folks have been real supportive of us, and I wanted to thank everyone for what they've done so far. What I really want to do is to remind folks that this OLF fight is not over. I've had a few folks come to me and ask me if it was over. They hadn't heard anything about it. You may have read some things in the paper about the Navy maybe perhaps having a deal with Franklin, Virginia, with the airport up there. None of those things are ending this OLF situation. The study for the OLF still continues. It's going to continue, so it is not over. I also want to remind folks that we will be having an OLF community meeting on Thursday, October 28th at 7 p.m. The Moyock Library, that's located at 126 Campus Drive in Moyock, which is off of Tulse Creek Road. We'll be giving an update on where we stand with the situation, and we'll also have a question and answer period. So, invite all to come out, as many as you can, and get the information. And finally, I'd like to remind everyone that the county still has the jet noise flyover incident report form online on the county's website. I encourage folks to use that. The flyovers are still occurring, to my knowledge. And finally, I'd like to leave folks with our groups, our organization's website has lots of information on it. Please feel free to visit the website. It's www.noolfcurrituck.org. Thank you. Appreciate it.
Troy,
Yes.
one more time. What was the date of the meeting and the time?
The date of the meeting is Thursday, October 28th,
Okay.
7 p.m. at the Moyock Library.
I have one more point. I think you recall in the meeting over at Camden that we had recently, they indicated it was still critically important for all of the citizens to continue calling and making contact with the various people, the representatives here in North Carolina, but also the Navy.
Right.
And keep the word going. Don't take the pressure off just because you've called them once, call them again. In fact, that might be something you put on a tickler every week to follow up with.
Exactly. That's great advice, and certainly we got to keep the pressure going. And like I said, a lot of folks have kind of seen this fall off of the radar a little bit. And emphatically, I want to tell people it is not over. It's very much a real possibility that this could come here. So folks need to stay engaged.
Mr. Chairman, just
Yes.
one more comment.
Yes, ma'am.
You thanked us. You've done a lot more work than we have, so a thank you to you and Juanita Kraus. They've been working on this for the past 3 years and have got lots of information. If you got a couple days, you can sit down and talk with them. They can fill you in. But we appreciate very much all the work that you've done.
Thank you.
Thank you.
Thank you.
We certainly appreciate it.
Thanks, everyone.
All right.
Love to stay, but I got to head to a volleyball game for my 11-year-olds.
Understand.
Thanks.
Thank
Mr.
you.
Chairman, do
Yes,
we
sir.
have all the information about the meeting next Thursday on the website and on this cable? Thank you.
Is there anything else? That's all I had. Sign up for public comment. Is there anyone in the audience who wishes to speak that did not sign up? Okay, that's for agenda item, but for the commissioners.
Let me say a word, if you will.
Yes, sir.
I told Commander Bob Kohler, he's the commander out at Post 288 of the American Legion, that I would thank the commissioner. He asked me to thank the commissioners tonight for what they did to bring the moving wall into his permits. Everything just worked so smooth. Dan called him and told him anything he needed out, just let them know, and they would do anything they could. But I just wish everybody in the county could have gone and seen that moving wall that we had in the low end of the county. Since Thursday, it come in late Thursday afternoon, left today about 3 o'clock, and the closing ceremony was at 1 o'clock. And some 6,000 people went in those little less than 4 days to see that. But I tell you, if you stand there and look at that, and you see those 58,000 names on that wall that are dead because of freedom in this country, and the average age of those people are 23 years old, it's a moving experience that I wish everybody in this county could have stood there and looked and heard that closing ceremony that we heard this afternoon. There were 6 of those people on there from Currituck County, and there were 6 of those boys' names on that wall were 16 years old. But I tell you, when you hear people say freedom is not free, you can look at that wall and you can really see it's not. But it was just a moving experience, and I'd like to see us send a letter to Commander Kohler and the American Legion 288 in appreciation of bringing it here, because they are really the ones that brought it in. It's just such an experience and a great thing for the county, really.
You make that happen, Mr. Scanlon.
Yes, sir.
Anyone else have anything?
Can I make a comment up front while we have the audience here?
Yes, sir.
Since they tend to dissipate after the causes
It's
are
amazing
handled.
how that works.
You'll notice my little tab here that I got today from voting early. You can too. Go do it. It's easy. There's no lines. Go right through. So go get it over with, over at where the election office is. And the other thing is, you'll notice that Commissioner Nelms and myself have on pink, and I think Commissioner Etheridge has on the tie that's very close to pink. That's in remembrance of the fact that October is National Breast Cancer Awareness Month. Please support the effort to eradicate this horrible disease anywhere you can. We appreciate that. Thank you.
As close as I could get to one.
Anyone else? I have one thing before we close the public comments. I was approached by someone last week about putting some warning signs up south of Coinjock for the bears. That we've had people, this is the time of year typically when the bears are crossing the road in the night and they're black, the road's black, and we've had a lot of people that hit those bears. Fortunately, we haven't had anyone get killed from it, but it has scared a lot of people, and I think it'd be appropriate if we asked, I don't know if it would be WRC or DOT or if the county could do it, but we need to put some signs up as you come off the Coinjock Bridge, probably all the way through to Grandy.
Yeah.
Because there are a lot of bears there. Yeah, I see them. Unfortunately, I haven't hit one, but they do get hit. So if the board would concur with that, I'd like to ask that we have the staff investigate having some signs put up warning about the bears crossing.
That won't be a problem this week. They play in Washington, D.C.
Yeah.
I didn't know bears could read.
Yeah. All right. With that, I'm going to close the public hearing, and we'll move to item 3. Public hearing and action, PB 00-06, Robert F. London Incorporated, pursuant to order of Currituck County Superior Court, rehearing of the application of Robert F. London, Inc. for special use permit for an adult-oriented nightclub at 9098 Currituck Highway, Point Harbor, Poplar Branch Township, parcel identification number 0132-000-133A-0000. Mr. Woody or Mr. McCree?
Yes, Mr. Chairman. If you would like, I'd be glad to officiate over this hearing.
Yes, sir. Do I need to swear in first, or would you like to
I thought
speak
what I would do is
first?
I first would make a comment about what this type of hearing is about, because it's much different than when you sit usually in your legislative capacity. And then at that point, I think it'd be appropriate to swear in any person that intends to present evidence to the board. As the chairman said, this is indeed a special use permit hearing. A special use or special use permit refers to a situation in which a particular kind of use is permitted in a zoning district, not as a matter of right, but under ordinance provisions that allow the Board of Commissioners to issue a special use permit when the board makes specified findings. In addition to finding compliance with specific provisions of the Unified Development Ordinance, the Board of Commissioners may affix other reasonable and appropriate conditions to the special use permit for the protection of both neighboring properties and larger public interest. Pursuant to the Currituck County Unified Development Ordinance, the Board of Commissioners must be able to find and conclude from evidence presented during the course of the hearing that the application is complete, the proposed use of the applicant's property is among those listed in the table of permissible uses as a special use permit, the conditions proposed meet or exceed the minimum requirements of the Unified Development Ordinance, the special use will not endanger the public health or safety, the special use will not injure the value of adjoining or abutting property and will be in harmony with the area in which it is located. The special use will be in conformity with the land use plan or other officially adopted plan, and the special use will not exceed the county's ability to provide adequate public facilities, including but not limited to schools, fire and rescue, law enforcement, and other county facilities. For the purposes of this hearing, the board sits as a quasi-judicial body. That means the Board of Commissioners is required to comply with certain procedural rules, much like those in a court of law, and to provide for the constitutional right to due process, such as sworn testimony of witnesses, no reliance upon hearsay testimony for critical findings of fact, and the direct and cross-examination of witnesses. Accordingly, those offering testimony will be placed under oath, and only sworn testimony will be considered by the Board of Commissioners to make its decision. The Board of Commissioners' findings must be supported by competent material and substantial evidence presented during the course of the hearing. Competent evidence is generally understood to mean that evidence which is legally admissible in a court of law. Pursuant to Section 160A-393 of the North Carolina General Statutes, the requirement for competent evidence does not preclude reliance by the Board of Commissioners on evidence that would not be admissible in a court of law if, first, the evidence was admitted without objection, or secondly, the evidence appears to be sufficiently trustworthy and was admitted under such circumstances that it was reasonable for the Board of Commissioners to rely upon it. As further provided by Section 168-393 of the North Carolina General Statutes, competent evidence does not include the opinion testimony of lay witnesses as to any of the following. The use of property in a particular way would affect the value of other property. The increase in vehicular traffic resulting from a proposed development would pose a danger to the public safety. Matters about which only expert testimony would generally be admissible under rules of evidence applicable to the trial courts. In addition, the board may not make a critical finding based solely on hearsay. Hearsay means a statement not made at the hearing that the proponent seeks to have admitted as evidence of the truth of the matter asserted in that statement. A witness or expert needs to be present so questions can be asked about the particulars of their statement. An example would be a petition, which is not valid evidence that can be considered in making a critical finding of fact. The person signing the petition must be present in order that they may be questioned and cross-examined. As provided in Section 14.4 and 11.7.1 of the Unified Development Ordinance, the burden of presenting a complete application required by the Unified Development Ordinance to the Board of Commissioners is upon the applicant. Once a completed application has been submitted, the burden of presenting evidence to the Board of Commissioners sufficient to lead the Board to conclude that the application should be denied shall be upon the parties urging denial, unless information presented by the applicant in its application and at the hearing is sufficient to justify a reasonable conclusion that a reason exists to deny the application. A couple other quick points. There is a court reporter present who is transcribing these proceedings. No one should feel intimidated or uncomfortable by that fact. She has been retained by the applicant, which is their right, and her purpose is to make an accurate transcription of tonight's proceedings. There may be cross-examinations of witnesses, but anyone who is under cross-examination should understand that it's not meant to intimidate or harass them, but to fully elicit and examine facts presented by them to the end of providing this board with the best evidence available. With that, Mr. Chairman, we propose we proceed in the following manner with this hearing. First of all, planning staff will present through Mr. Woody a case review analysis of this application. Then the applicant will have the opportunity to present their case. At that point, then those who are in opposition or in favor, of the application will have an opportunity to come up and speak. Those who are in opposition to the application will have an opportunity to come up and speak. Those persons who are not direct witnesses of the applicant or the county, for that matter, but are coming to give their opinions or views or testimony relative to the application will be asked to keep their comments to 3 minutes and to make sure that what they are saying is indeed relevant to the issues that are before the Board of Commissioners, as I've just spoken about. There then will be an opportunity for the applicant to present any rebuttal evidence to address any of the issues raised by those persons from the public who have presented any evidence or testimony to the board. The board will have the opportunity, of course, throughout to ask questions of any witness or party. Then the evidentiary phase will be closed by the board, at which time the board will deliberate and make a decision regarding this matter. So with that, Mr. Chairman, I would suggest that you now have all those who intend to testify or present evidence to the board during the course of this hearing come forward and be sworn.
Anyone that wishes to speak in this hearing, this is the time that you come forward to be sworn. I ask you to place your left hand on the Bible and raise your right hand. Now, if you do wish to speak to this issue, you have to come forward now. We're doing one swearing in. Okay, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you.
Mr. Woody, you may now present the staff case review and analysis.
Thank you, Mr. McCree. This request is a special use permit. It's actually a rehearing. The original hearing of this application came in the year 2000. What I'm going to do tonight is I'd like to say briefly, but it probably won't be briefly, but go through some of the context of this case and go through each of your findings that you have to make. Mr. McCree just went through the numerous findings that are required of a special use permit, so I want to address each of those findings individually. And to start it off, what you're basically looking at tonight is a special use permit to operate an adult establishment consisting of a nightclub that offers comedy, pool tables, video games, musicians, dancing, topless dancing, organized parties for businesses or groups. The property is located on 158 on the west side of 158 in Point Harbor, in the south end of the county. The building is now occupied by Mermaids Nightclub. On the aerial photograph on the screen, you can see the subject property highlighted in red. Property is currently zoned general business under our zoning ordinance. You can see to the west or kind of southwest of that, it backs up to property zoned residential. And of course, on the primary zoning pattern you see in this part of the county is a mix of general business and residential zoning. What I'm going to do now is I'm going to go through each of the criteria and staff findings for those criteria. Then I'm going to give you the staff recommendation. Then I'm going to finish up with the planning board recommendation. So I'm going to start just with number one and take them off as I go through.
Mr. Chairman, Question, Mr. Woody.
Sir.
Are these criteria and findings the same as those in 2000, or are they the findings today?
They are the same as the ones in 2000. We basically carry those forward. Now, I'll say that they're different section numbers, which I tried to highlight the differences in section numbers from 2000 to today. And a couple of things changed slightly, and what I did is I kept the findings that existed in 2000, and then things that have changed or differences I put in parentheses in the text. So I tried to account for both, but to answer your question, they're basically the same.
I would ask the county attorney then, is our judgment based on the changes, or is our judgment supposed to take the evidence as it was presented in the year 2000?
Well, I think that the applicant should be accorded the same ordinance that was in effect, or the same requirements that were in effect at the time they made application. But as Mr. Woody said, our ordinance is the same, I think, in all respects, except for the fact that we have gone through a renumbering of the ordinance. So the requirements in 2000 are the same as the requirements today for an adult establishment.
Thank you.
And with that, I'll get into the first finding. Your first finding as a Board of Commissioners is to determine if a complete application was filed. Staff finds that a completed application was filed on February 7th, 2000 for a special use permit. Your next finding is whether the proposed use, in this case an adult establishment, is among those uses listed in the table of permitted uses as a special use permit. Staff finds for this finding that the use is not allowed under the permitted uses table. While the requested permit is for an adult-oriented business, an adult-oriented business requires a special use permit. However, it must be zoned heavy manufacturing. In this instance, the property in question is zoned general business, and before the applicant could submit a special use permit application, they must first apply for a rezoning of that property from general business to heavy manufacturing. So staff does find that that criteria cannot be met. The third criteria is that the conditions proposed meet or exceed the minimum requirements of the UDO of this ordinance. Staff finds the application is not in compliance with the requirements of the UDO, and I want to give a little context on that and kind of go through the reasons why we made that suggested finding. I'm going to go back a little bit in the timeline to get to this. In a letter dated April 1st, 1996, Mr. Robert F. London submitted a written statement indicating the type of entertainment being offered at Mermaid's Nightclub. In that letter in 1996, that was the first time that Mr. London submitted any type of request for topless dancing and or adult-oriented activities. Prior to April 1st, 1996, the county never received a request to operate an adult-oriented business. On May 29th, 1996, the Board of Adjustment held a public hearing and denied R.F. London Incorporated's conditional use permit application for an adult and sexually oriented business, based on the reasons stated in the June 4th, 1996 order that was signed by the chairman of the Board of Adjustment. On July 8th, 1996, Mr. Robert F. London appealed the Board of Adjustment decision to Superior Court. On September 28th, 1999, Superior Court Judge Jerry Tillett ruled the Board of Adjustment shall rehear Robert F. London, Inc.'s conditional use permit pursuant to Sections 1304 and 808 of the UDO, or Unified Development Ordinance, and that the Board of Commissioners shall consider the applicant's proposal pursuant to Section 808 of the UDO and make specific findings of fact and conclusions of law to address the following. These are the findings that Judge Tillett has ordered this board to make. I'm going to go through these. Number one, the petitioner's initial intended use. Number two, the secondary effects of the petitioner's initial use. Number three, the petitioner's amended use. Number four, the secondary effects of the petitioner's amended use. And number five, how the secondary effects are affected by the different intended uses. Now, staff will address or make recommendations to address Judge Tillett's order, and that'll come later in this presentation or analysis. Following the public hearing for Robert F. London Incorporated's conditional use permit, the permit was revoked. Therefore, Mermaid's Nightclub does not have a conditional use permit to operate an adult business nightclub. That was then, and that continues today. Further, Mermaid's Nightclub is not considered a nonconforming use under Article 15 of the Unified Development Ordinance because it has no permit to operate under. So what that's saying is basically the Board of Adjustment denied that permit for an adult establishment. Since there was never a permit in place to grant them permission to operate, therefore, staff's finding is that you can't argue the use is grandfathered. Robert London Incorporated or any subsequent party does not have a vested right to operate Mermaid's Nightclub either. That's because Section 2019 1 and 2 of the old ordinance, presently Section 11.12 A and B, of the UDO requires a use permit to obtain a vested right. As I mentioned previously, they do not have a use permit for an adult establishment. Mermaid's Nightclub has continued to operate an adult business by allowing topless dancing. Mr. London was convicted in district court for operating Mermaid's Nightclub without a conditional use permit, paid the fine, and was ordered by the court to not operate until he had a valid permit. Sections 808 and 1310 of the UDO, presently sections 3.7.1 and 2.5, were the old sections adopted in September 19, 1994, classify topless nightclubs as an adult business, which requires such businesses to locate any heavy manufacturing zoning district with a special use permit and be 1,000 feet from any dwelling or R and RA zoning district. So those are the criteria that were adopted by the Board of Commissioners in 1994. The property on which Mermaid is located, U.S. Highway 158, Point Harbor, Tax Map 132, Lot 133A, which you see highlighted in red on the screen, is zoned general business. Further, the building in which Mermaid is located is within 1,000 feet of 24 residential dwellings. It was 17 dwellings in the year 2000, and immediately adjacent to an R zoning district. Thus, it doesn't meet the separation requirements that exist in the Unified Development Ordinance. Because Mr. London did not submit a completed special use permit request for a nightclub offering topless dancing until February 7, 2000, and Currituck County adopted an ordinance that regulated adult establishments on September 19, 1994, then the provisions of the September 19, 1994 ordinance contained in sections 808 and 1310, presently sections 3.7.1 and 2.5, do apply to this property in this situation. The adult business nightclub application of Robert F. London, Inc. does not comply with the former or present applicable requirements of the Unified Development Ordinance, since the property is in a general business zoning district and requires HM zoning, is immediately adjacent to residential zoning and requires 1,000-foot spacing, and is located within 1,000 feet of 24 buildings containing residential uses. Therefore, the use does not meet the minimum requirements of the UDO, and staff feels that finding cannot be met or made. And I have a map there I want to show real quickly. You can see the subject property highlighted in red. And from the building, we have drawn a 1,000-foot buffer, and within that 1,000 foot is an area that cannot contain residential zoning or dwellings used for residential purposes. So you can see on the evidence presented there that there are residential dwellings that are within that 1,000-foot buffer, and that's the separation requirement I just referred to, in addition to the incorrect zoning. Finding number 4 that the Board of Commissioners has to make is that the special use will not endanger the public health or safety. Staff finds the proposed use will materially endanger the public health or safety for the following reasons. Mermaid's Nightclub is immediately adjacent to a 29-lot residential subdivision known as Old Oak Estates, which currently contains 21 dwellings. Old Oak Estates is also zoned R residential, and again, Mermaids is within 1,000 feet of those dwellings and that residential zoning district. Secondly, Mermaid's Nightclub does not meet the locational requirements. And what I mean by that is the property is currently zoned GB and needs to be zoned heavy manufacturing to meet that requirement. And again, I'll reiterate, it doesn't meet the spacing requirements of 1,000 feet from residential zoning district and 1,000 feet from residential dwellings. So staff feels that criteria cannot be met either. Criteria number 5, the special use will not injure the value of adjoining or abutting property and will be in harmony with the area in which it is located. Again, staff feels the proposed use will substantially injure the value of adjoining or abutting property and will not be in harmony with the particular neighborhood or area in which it is to be located for the following reasons. Mermaid's Nightclub is immediately adjacent to a 29-lot residential subdivision known as Old Oak Estates, which contains 21 dwellings. Old Oak Estates is Zone R, and again, Mermaids does not meet the 1,000-foot separation from the R zoning district or the occupied residential dwellings. Mermaids Nightclub does not meet the locational requirements of the zoning ordinance. Again, the property is zoned general business but requires heavy manufacturing zoning. And finally, a review of County Tax Office property valuation histories between 1990 and 2000 for the 27 lots in Old Oak Estates shows 24 properties decreased in value a total of $88,895, and 3 properties increased in value a total of $5,321. The net decrease in tax base for Old Oak Estates between 1990 and 2000 is $83,574. Mermaids Nightclub began offering topless dancing in the summer of 1994. Finding number 6 that the board has to make is that the special use will be in conformity with the land use plan or other officially adopted plan. Staff finds that while the proposed use does conflict with our Unified Development Ordinance, it does not conflict with the adopted land use plan or other plans. Finding number 7 is that the special use will not exceed the county's ability to provide adequate public facilities. Again, on this one, staff finds the proposed use is commercial and will not generate additional school children. Therefore, it does not have a negative impact on our ability to provide adequate public facilities. Those are your 7 findings that are required of you through the special use permit process, and I've just reviewed the suggested findings by staff. With that, I'll go to our recommendation. Staff does recommend denial of the special use permit based on the following. The proposed use does not meet the requirements of the UDO, the required finding under previous section 1402(1)(c), presently section 11.7.1(f)(12)(c). It does not meet the requirements of the UDO because the zoning is improper and it's currently zone GB and requires HM zoning. The adult business building is within 1,000 feet of a residential zoning district, and it is within 1,000 feet of 24 buildings that are used as residential dwellings. And to address Judge Tillett's required findings, I would note in accordance with that, staff provides the following findings. The applicant's initial intended use was a nightclub and billiards game room. A conditional use permit application to appear before the Board of Adjustment for the initial use was submitted on August 4th, 1993. The secondary impacts of the initial intended use were encompassed in the findings of fact adopted by the Board of Adjustment on January 26, 1994, and is included in a package of exhibits that you have in your possession. On February 7, 2000, Robert F. London Incorporated submitted a special use permit application to operate an adult and sexually oriented business consisting of a nightclub offering comedy, pool tables, video games, musicians, dancing, topless dancing, organized parties for businesses or groups. The property is located on US 158, Point Harbor, in the building now occupied by Mermaids Nightclub, Tax Map 132, Lot 133A, Poplar Branch Township. And the final finding requested by Judge Tillett is that secondary effects of the amended use, which is the adult establishment, are considered under the special use permit criteria of Section 1402.2, presently Section 11.7.1 F12. However, the secondary effects do not apply because the controlling statutes, former Sections 808 and 1310 of the UDO, require adult-oriented businesses to locate in a heavy manufacturing zoning district. Further, Section 808 of the former ordinance requires a minimum 1,000 feet spacing between any building housing an adult-oriented business and an R zoning district and any building used as a residential dwelling. The proposed adult use building is located within a GB zoning district, is immediately adjacent to R zoning district, and is within 1,000 feet of 24 buildings used as residential dwellings. Finally, the Planning Board recommendation stems back to April 11, 2000. At that meeting, the Planning Board recommended denial of the request subject to the following. The proposed use does not comply with the requirements of the UDO. because the zoning district, GB, does not allow adult and sexually oriented businesses with a special use permit, and because the building in which a nightclub is in is within 1,000 feet of residential dwellings in the R zoning district. And finally, the proposed use will not be in general conformity with the UDO, which is officially adopted by the Board of Commissioners. That concludes my presentation. I'll be happy to answer any questions you have this time.
Members of the board have any questions for Mr. Woody?
One question, Mr. Woody. Has the proposed applicant ever applied to the planning board for a rezoning?
No, sir.
Never filled out an application to the county staff for a rezoning?
We have
for
no
proper zoning?
We have no records of that, no, sir.
Thank you.
Any other members of the board have questions for Mr. Woody at this time? All right. Ms. Plummer, would you like to ask Mr. Woody any questions at this point?
If I can reserve my right to ask questions, maybe I can move a little more quickly with our presentation. I think Mr. Woody's...
If you first state your name and who you represent in this matter.
My name is Brian Plumley. I represent the applicant, RF London. And to your question, Mr. McCree, I can go through my questions now since I'm up here. We can go forward with a few questions for Mr. Woody
you had asked, I must say up front, that to at least enter some objections to this proceeding on the record. We have already started, but go ahead at this point and put your objections on the record, if you will.
Thank you very much. Again, Brian Plumley for Robert F. London, Inc. These are objections we'd like to make on the record to preserve, should this go beyond this body's consideration of the matter. First, that the county's Unified Development Ordinance is unconstitutional on its face as written as it pertains to this use, that the ordinance is unconstitutional as applied to this use and to this applicant. It unconstitutionally violates Mermaid's rights and the applicant's rights to free speech. It treats this business different than others and is unconstitutional under the Equal Protection Clauses of the United States and North Carolina Constitution. This business has at all times operated as a use at this location for 17 years prior to the requirement of a special use permit, that the UDO sections requiring adult uses and sexually oriented businesses such as this to be operated only in a heavy manufacturing zone with a special use permit is unconstitutional because there is no reasonable location anywhere in the county to relocate. That this hearing is not necessary due to the vote of this board on December 4th, 2006, when the board voted to drop the lawsuit involving this business. That the initial order to hold this hearing came about in 1999 through Judge Tillett's order. So that's been approximately over 10 years ago, to provide a full record to the court. And until tonight, the county has failed to comply with the court's order. And as a result, this business continued to operate during that time and has been prejudiced in that there have been witnesses who could otherwise come to testify on matters that occurred years ago that are no longer available. Memories have faded. Most importantly, since it's continued to operate, it's expended significant funds in updating its facility. Further, that the commissioners should not vote to deny the permit because it would be a revocation of an approval already given by the board in 2006. That the Board of Commissioners, and I'll get into this more specifically during the presentation because all these objections I'm not going to bring out during the testimony, but the board has the power to alter the specific requirements of the UDO due to extraordinary circumstances and award the special use permit. And obviously, since it's been operating for 17 years, there are extraordinary circumstances in this situation where the board could attach additional requirements to this business to protect any of the policy reasons stated by Mr. Woody, place those conditions in order to limit the business appropriately. I want to specifically object to the use of the tax records for the period reference from 1990 to 2000. That predates the actual business by 4 years and leaves out the last 10 years as evidence for secondary impacts. Also, I believe Judge Tillett's order was very specific about the findings to be made by the commissioners, which Mr. Woody did go through, and I would like the opportunity to present the board with the actual order from Judge Tillett. And going to the point of the Planning Commission, this has not been reviewed by the Planning Commission since 2000, and to be a proper special use permit application presented to this board, it should go back to the Planning Commission. So those are my general objections, Mr. McCree. And I would have very few questions for Mr. Woody on his presentation of evidence, if that's permissible at this time, if you'd like that.
Your objections are noted for the record, and then if you can now proceed with your question of Mr. Woody.
Just going through the specific findings, Mr. Woody, the issue over the completed application is the finding of staff is that there is a complete application, just to establish that point. Is that correct?
Yes.
Okay. Now, there is a very long discussion on whether the findings would meet the minimum requirements of the ordinance, and I'm going to get to those. But before that, we talk about heavy manufacturing and general business. At the time, a conditional use permit was issued to RF London back in 1993. It's correct that there was no prohibition, specific prohibition against this type of use within general business. Is that your understanding?
No.
Okay. Can you explain that?
In the UDO, if a use is not specifically listed as a permitted use, it is then deemed to be a non-permissible use.
Was that the content of the UDO in 1993 as you're aware of it?
As I'm aware, yes.
And you've been employed with the county for 37 months, correct?
37 months,
okay. Yeah. And your review has been a file review primarily or exclusively, correct?
Yes.
Okay. And in discussion of the impacts to value, you looked only at tax records. Those were assessed values, is that correct? During a period from 1990 to 2000. Was that your research or was that research performed by someone else?
Research performed by the previous planning director.
Okay. And that research then would be dependent upon the review of that previous individual, correct?
Yes, I mean, it's based on the tax data, so I think that's a known quantity, but yes.
But those were not transactions, those were assessed values, is that right?
Yes.
Okay. Those are all the questions I have for Mr. Woody. Thank you.
Okay. Any further questions from members of the board based on Mr. Plumley's examination of Mr. Woody?
I'd like to point out to Mr. Plumley, because I was the chairman on the board when we dropped the lawsuit, and we dropped the lawsuit for one purpose only, and that was to save Currituck County a financial extremely amount of money that we had been dealing with for years. At no time did we ever indicate that we were not going to go forward with the request from Judge Tillett, which is what we're doing here today. And at no time did we advise Mr. London, he talked to me at least 4 or 5 times then, that we were issuing him any permit. And Mr. London understood that. And that's my testimony. As for the comment that you made to Mr. Woody, I was a chairman and vice chairman on this board back in 1980 to 1984, up till this term right here. And it has always been the policy of Currituck County that if it's not addressed, then it is not allowable, whether it's building or whether it's zoning. And that's the way Currituck County has always operated, and I wish to record that.
Okay, anything else from the board at this point? If If not, Mr. Plumlee will present your case.
Yes, sir. I would like to, I think I can be brief by explaining what documents I would like to present, and you can decide if you want to object to their use during the proceeding. If so, I would like them kept for purposes of consideration by any other body if necessary. If I could go through those one by one for you to consider.
And let me just quickly, I earlier gave you a copy of the affidavit of the clerk to the Board of Commissioners with a number of documents that were spoken about in Mr. Woody's presentation. Without objection, we'd like to ask that.
I have no
admitted as
objection.
The county's exhibits.
I have no objection.
And at least the board can go ahead and have those in front of them at this point.
Should we recess and read these? Okay, Mr. McCready, this first is the order of Judge Tillett from 1999. If you have no objection, I'd like to present that. It is not already, I didn't see it in the documents that you provided. I did see Judge Cy Grant's order, but I didn't see the...
Certainly no objection to that.
Okay. You already have Judge Grant's order, so I'll set that aside. My client has retained an appraiser to discuss market value, and she is, her name is Lauren Berry. She has provided an analysis, which is about 1 page, 2 pages with a couple of attachments, and her resume that I would like to present as exhibits for the board's consideration.
She'll be testifying.
She's here to testify, that's correct.
All right. I don't think there'll be any objection to that.
This is the analysis. This is the resume. There are a number of exhibits that I'm going to pull out. I don't believe that are necessary to submit, and it will leave some gaps in numbering if that's at all confusing. But it may make things go more quickly. So far you have items 1, 3, and 4. They should be marked. And this will be item 11, and what it is the transcript of proceedings for December 4th, 2006. I don't know if you have any specific objection to that, but I would like to make that part of the record.
Let me just see it first.
Mr. Plumlee, do you have one more copy of the appraiser's resume?
I did.
Mr. Gregory?
That's okay. It's all right.
No, certainly no objection to the transcript of proceedings from the December 4, 2006
Thank you.
Board of Commissioner meeting.
The last item, Mr. McCree, I do anticipate an objection, just to give you fair warning. This is these are signed statements by members of the public living within 1,000 feet or having businesses within 1,000 feet of this business, and we would like to make this part of the record as well. These people could not come to testify tonight for whatever reason, and while I can understand an objection to it, I will say, in reviewing the document, you'll see that there's, I believe, sufficient reason to believe they're trustworthy signatures of persons living. They provide the address of the individual. They provide their signature, and so if I could hand you up the copies of this without distributing them, I will bring up my client to talk about them at some point, and we can decide whether you want to place objections, but I could at least keep one in the record as proffered to this board for consideration, if not accepted.
Proffered, but of course those persons are not subject to cross-examination, and therefore obviously the petition is objected to. Understood.
And I will not hand up then all of the copies to be distributed then, if that's your preferred method. Okay.
That'd be fine.
For the purpose of speeding this meeting along, I do want to make certain points that while I'm not testifying, I'm an attorney and I don't testify for my client, I present, there are certain points that we can concede, I think, to keep things moving along. Mermaids is located in a general business district. That is not disputed. Mermaids has not filed for rezoning of this district. There are residences within 1,000 feet. We are willing to concede those points for the purpose of making our presentation and keeping things moving without excessive debate and wasting people's time. However, we do believe that the commissioners have the authority to allow this business to continue to operate. It's been operating for 17 years. There have been no incidences reported of any negative type taking place at this location, of any threat to public health. I think that just going through these suggested findings, and I'll do this very quickly, we have a complete application. We concede that it's within 1,000 feet of a residence and that it is not a heavy manufacturing district. However, we do refute that this will in any way endanger the public health or safety at its current location. We don't believe that there's any evidence that's been provided by staff or will be provided by anyone this evening to support that. We don't believe it will be injuring the value of any adjoining or abutting property with regards to value, and we do have expert testimony on that matter. As Mr. Woody did point out, it is in compliance, or conformity with the current land use plan, and so therefore does not violate the land use plan. It doesn't create any type of strain on the county's ability to provide public facilities of any kind, fire, water, etc., any school requirement. So the basic issue is whether it should be allowed to continue though not in strict compliance with the minimum setback and with the general business zoning that it is currently within. That, I believe, there's a strong fairness argument to be made with regards to this business. I wouldn't be here representing them if I didn't believe that there's a strong fairness position for my client after 17 years at this location. 2006, while I understand Board Member Nelm's recitation of what that meant at the time, it did mean to my client that they could continue to operate. There was no attempt by the county to enjoin its operation up until very recently. That was in April of this year. After that notice of violation came from the planning department after years of operation, we filed a motion on behalf of our client with the Currituck County Superior Court. Once that was filed, this hearing was noticed, and a motion was filed on behalf of the county to prevent that hearing from going forward based on the fact that tonight's hearing needed to be done. Otherwise, all administrative remedies would not have been exhausted. So while there has not been a hearing in all these years, the reason why this is coming up now, we believe, is because Mr. London found a partner to come in and invest with him, that they made certain upgrades, and that one day the sign changed names from mermaids to headlights. And that created an objection in the community, which was conveyed to the county, which then responded by submitting, by noticing violations. I won't go through the lengthy arguments that we've presented previously to the Board of Adjustment, but I do want to give my client the opportunity to talk about secondary impacts, and the reason for that is that in the Superior Court, Judge Tillett in 1999 said what you're supposed to do is determine what the intended use secondary impacts would be and what the amended use secondary impacts would be, and that's the discussion for this evening. So I want to present that material, and I'd like to do it in two steps. First, by putting up Ms. Lauren Berry to talk about that information, to put that before the board, and second, by bringing up my client, one of my clients, Mr. Robert Brown, to talk about his investment in this business and the need for it to go forward. There are others who would like to talk about the fact that it's not creating any negative impacts, and I'm sure there are a few here to speak in opposition. So I think that's kind of a roadmap for the witnesses that we have to present, and I'd like to begin by calling Ms. Lauren Berry, if I could.
Yes.
Good evening. Mr. London hired me to do a market analysis on the... What do you want me to say?
If you state your name and address for the record, please.
My name is Lauren Berry. I live at 102 West Canvasback in Currituck, North Carolina. And Mr. London hired me to do a market analysis. I mainly emphasized my research on Jarvisburg and towards the bridge. In my findings, I wanted to look at the concurrent market before the property started operating as this type of establishment. So I went back a year before it opened, and I'm sorry, am I squealing to everybody else?
That's better.
And I wanted to establish what the market values were previously. I went through the county tax records because our MLS has been purged every 5 years, so that information was no longer available. And went through the county and found all the valid sales and transactions that had happened since then. From there, I analyzed mainly price per square foot, package price. That way it kind of alleviated any deviations, and with large acreage, because of course large acreage sales for at a less of a premium. And what I found was beforehand, as in your little brief synopsis, that per package price it sold for $45.40. a year afterwards, I did the same analysis, and it sold for $66.71. That was an appreciation. By no means do I think that this business increased the property values, but it doesn't show that it's decreased. The price per acre was about the same. You don't have that in your handout, but it increased about $2,000 per acre as well. There was a little less data on that because there wasn't that many sales, so I wouldn't really feel statistically that was a firm number, so that's why I didn't include that in the analysis. Just looking in the overall market, I didn't see a decrease in population growth. Per the U.S. Census thing that's also in your handout, I actually saw an increase in population even around the subject property. And then as well as I looked at under the U.S. Census for the whole zip code of the Poplar Branch area and found a steady basis in business growth. There was a stagnant in 2004, 2005, with 2 more businesses added in 2006 and 2007-11, and after that there was a large growth to 23 businesses in 1998.
Just a few questions for Ms. Berry pertaining to her resume. Thank you. We'd like to tender her as an expert in the field of appraisal. Can you tell the board your qualifications to provide this information?
Of course. I'm sorry. I'm a commercial real estate appraiser. I've gotten my master's degree in business administration from East Carolina University, and I've been in the appraisal business since I can remember, with my father as well. So I've kind of been around real estate forever, and I grew up in Currituck. I'm very familiar with the area and the market.
Mr. Woody, during his presentation, provided information concerning appraised values for properties adjacent to or near this particular business. Can you provide the board some thoughts with regards to the use of appraised values?
Tax values is based on mass appraisals. They don't look at individual properties. They don't look at, they have a basic price per acre based on whether the property is on a paved road, whether it's near the water and adjacent to the water. Overall, it's good for what it's used for. You know, it's an excellent way that they can put it in a tax assessment, and you can have pretty much a fair idea, and everyone is taxed on the same basis. In no way do you use that as a market value. Normally, that's why we have appraisers. It's good for what it is, but not a bank would never loan on a tax value. You need more of a specialized opinion on that. As far as Acorn goes, in 2008 through 2010, there's only been one sale that was valid that I could see, and that pretty much went for a market rate as opposed to the rest of our market. So I didn't really see a decrease there. I can't really attest to what it was before, but currently that sale was in this year, and it sold for $239,900, and it had 1,600 square feet roundabouts. So.
Those are my questions. Thank you.
Any members of the board have questions for Ms. Berry?
I do. Ms. Berry, I heard you say, and I was reading through this, you said from Jarvisburg south.
Yes, sir.
You were doing your appraisal.
Mm-hmm.
Is it really germane to appraise a home in Jarvisburg compared to a home that's adjacent to this? Did you do any appraisals within the 1,000 foot?
Well, I should also say that this is an appraisal. It's a market analysis. I did not do an appraisal on this property. I did not go in. I did not inspect it.
So you're doing a market analysis, not an appraisal?
Yes, sir.
Okay, so this is just what you say, the market from Jarvisburg going down south, so it's not really an appraisal surrounding the 1,000-foot or adjacent properties.
No, sir. This is the market area from Jarvisburg South. I excluded the Grandy area because of the anchor store. It's kind of a little sub-market, just like you wouldn't include Moyock Commons, and that's a little bit different than just regular Moyock. So,
Can I ask you another question?
Mm-hmm.
If you were doing an appraisal of a house or whatever, would you look for comparables in the area?
Of
Or
course.
would you look for comparables, let's say we were in Coinjock, would you look for comparables in Moyock, or would you look for comparables in the Coinjock area?
In the Coinjock area, if they were available.
Okay, so that's if you were doing a true appraisal.
Mhm.
You'd have to look at comparables. To do a market analysis, that's just what your opinion is of what the market was doing at that time?
Well, opinion based on fact, but yes, there's not that many. The data with 27 lots doesn't really have an accurate
Right.
pinpoint of the whole market of Jarvisburg or Point Harbor.
Okay. If nothing further, thank you. Do you have a question?
Just a minute, Ms. Barrett. Any other members of the board have questions?
Okay.
If I may just ask a couple questions to
course.
help the board out. Did you take into consideration the hours of operation of this particular, or the alleged hours of operation of this particular business during any period of time?
I looked at only transactions. I didn't look at how their hours affected. It was just property values and how they.
So you didn't really compare the active operation of an adult establishment on neighboring properties? What effect it might have on value, if any?
I think, say that again if you don't mind.
You didn't actually make a comparison of an active and operating adult establishment and that effect, if any, on the value of adjacent residential property, did you?
No, sir. I just looked at the market area.
Okay, and have you ever done any other market analysis or studies of similar situations in which involving an adult establishment and impact, if any, on residential use?
Not on the adult establishment, but I have done a market analysis for the USDA that encompassed 90 counties in North Carolina.
But what types of?
That worked on wetland, but it's basically the analysis and the data recollection and how you is the same. It's you're looking at market values and you're looking at how trends relate to each other. So the basis and the knowledge is pretty much the same.
I guess assuming that this particular use is the type of use that some might find objectionable and thus claim reduces value of property, have you ever done a market analysis of a use of land that some might find objectionable and thereby claim that there's a reduction in value of their property?
No, but I did use, I did consult with someone that had done that. So I had other opinions on someone who has this specialty in the past.
Did they actually come here and evaluate this particular situation?
They worked closely with me. Yes, sir.
But did that person or those persons actually come here and review the information and see the site and its location in relation to residential use?
He had actually done a market analysis on this exact property.
Okay. I have no further questions.
Okay, thank you.
I'd like to ask a clarification.
Of course.
It would appear to me that if we were to look at that 1,000-foot buffer area and wanted to determine the impact of this business on the value of those properties, that the appropriate method would be to look at the nearest adjoining comparables and compare those to the properties within this buffer and see what was the relative change in value, if any, immediately prior to and after the beginning of operation of this business. Does that make sense to you?
Yes, sir. If there's enough data available to make a sound decision, because one sale doesn't necessarily make a market.
I understand that, but to your knowledge then, was any such study like that ever done because of these conditions?
Not that I know of.
So we really have no way at this point of determining what the impact would be of that other than the methodologies that you have suggested. On one hand, is a market analysis, and the kind of aggregated tax valuation method that Mr. Woody has proposed.
I believe that a method of both would be appropriate, using both if the data is available. If it's not available, that's two different methodologies.
Okay.
Mr. Chairman, I do have one question.
Yes, sir.
Mr. Nelms raised an issue that we should be looking at this as we were sitting here in 2000. Is that correct?
Yes, sir, I do.
Well, I think to the extent that you'd be applying the relevant ordinances, and as I said, the ordinances are the same now as they were then, except for renumbering.
So what is the relevance of data after 2000 till now, or any other issues that might have arisen since 2000, since we're dealing with as it was in 2000?
Well, I think that's the determination you're going to make as findings of fact. Is that relevant to you or not?
Thank you.
Anyone else?
Mr. Etheridge brings up a good point, because if that's the case, then our decision in 2006 is irrelevant also. I do remember that in 2006 it was Commissioner Bowden who brought up the issue that Mr. Plumley brought up about the HM district, and the county was advised by former attorney, I can't remember who it was before Ms. McKenzie, but Mr. Morrison, I believe, anyway, doesn't make any difference, that the county could not exclude any particular business, and in fact, the county did in fact allow that business in an HM district, and it was allowable under that zoning, and we took that under advisement when we made our decision, didn't we, Mr. Gregory, at that time, and that was Mr. Bowden had brought that point up.
Any other questions from Ms. Berry?
Thank you.
Thank you.
Mr. Plum, you have any?
My only follow-up question was just to provide a quick reasoning behind the use of the method that you chose, if you could. I'm not sure if that came across through the questioning.
The reason why I chose this method is because there was a lack of data on Acorn Lane. There wasn't enough statistical data to even discern. I mean, you had a few sales, but not enough to be able to say a market.
Didn't you have the four houses that didn't he bring up there were four houses that were built during this period of time?
I believe
Built or
seven.
transaction?
Seven, were there seven?
Yeah.
And couldn't that data have been used?
Built or were they sold? I don't have the data in front of me that you're referring to.
I believe, if I can just help move things along, it was new homes built in that area coming to that area, not sales from that vicinity.
Well, it would still have relevance as far as the price range of what those houses sold for, I think.
If they resold, or if they sold or they resold.
Yeah.
I just don't have that data in front of me to be able to speak on it.
Yes, sir.
Do you know, Mrs. Berry, that if any houses were put up for sale during that period of time on Acorn and then no sale or not, then transaction not completed?
As I said, MLS is purged every 5 years, so that data is not available. I wish it was.
All right, anything further from the board from Ms. Berry? Anything else from Ms. Berry, Mr. Plummer?
No, sir.
May call your next witness.
Thank you.
Call Mr. Robert Brown. And if I could help just by asking a few questions while I'm up there of Mr. Brown to direct this a little bit.
And if he'd say his name and address for the record, I guess we'll get to that in your direct.
Yep, Robert Brown. I own Headlights Incorporated.
All right, Mr. Brown, can you explain to the board your experience with this particular operation in concerning impacts to neighbors and what investigation you've done and what you have found as a result?
Yes. You guys are just asking the real estate expert some questions. The house directly behind Mermaids, I know, was purchased within the last few years, and there's only one house for sale out there now. It's been up for sale for a short amount of time. I'm not a real estate expert, but I don't believe they've had any trouble. And I think several houses have been built. I think the comment was wrong before. Were there any houses built since that business has been there? And I believe that 7 or 8 houses have been built new since that location started out in 93. But I think what Mr. Plumlee's leading to, I took the time to go out to the neighborhood, and there's been a lot of talk about secondary effects around that business. And part of the reason for having the 1,000-foot buffer is because of secondary effects. So I went out to every street within 1,000 to 1,500 miles. Took a map from. Let me grab my study here. I took a map and carved out an area that I was going to go to all these neighbors and businesses and put a form together and ask them if they approved of the location or disapproved of the location, if they approve or disapprove of that type of business, and has it caused them any harmful secondary effects. And the way I come up with those questions were, the first time I hit Acorn Lane, I had different information with me, and I found that the residents in general were either had no problem with the business being there at all, and it had never caused them any problems, or they would say, I don't approve of that type of business. That's not the type of business that I would want to see anywhere. They just don't like go-go bars. Or they would say they disapproved of the location. In each instant that they said that, I would ask them, had they have any problems from it? And I heard minimal things from everybody on Acorn Lane. I know there's 1 or 2 that have some comments here tonight. But so that's how I got my questions together for the survey. And I'd like to go over some of my findings on that, if you don't mind.
I don't know if there's an objection.
There'd be a running objection to the extent that Mr. Brown indicates what any person not present tonight stated to him.
And if I could just say for the record that we're proffering this information so that Mr. Brown can go through that quickly.
For members of the board, what that means is there is belief that what Mr. Brown is about to testify to or may occur during the course of his testimony will be hearsay, which, as we stated at the opening to these hearings, you may not consider in making a decision. Now, in terms of the word proffer, what Mr. Plumlee is indicating to you is that he is making a record in case this is appealed to a superior court, and so he wants, in any event, to have Mr. Brown to state for the record and for possible review by a future court of what his testimony would have been and whether it should have been considered by the Board of Commissioners. All right, go ahead, Mr. Brown.
Thanks.
If it's hearsay, Ike, why are we hearing it? Because we cannot consider it. Those were your instructions.
Well, you may not consider it, but there is the opportunity for a party to present for the record, if they would like, what the evidence would be had you been able to consider it, so that a court can make a determination as to whether it should have been properly considered or not. But we would ask that you move along with
it won't take but a minute. So in the 4 days that I went out, I visited 64 households. The households that completed the survey were 29. Households declined the survey were 8, and 1 incomplete. 26 folks not home. So total households that completed the survey were 29. Out of 29, 26 did not oppose of the operation at its current location. 3 did object to the operation of its current location. 25 didn't object to the idea of a gentleman's club, and 4 did. But out of the 29 folks that we talked to, 0 said they experienced any negative secondary effects, and in fact signed that they hadn't experienced any negative secondary effects. That was the residents that I went to. The residents that declined to sign, most of them said they didn't have a problem with the business, but they didn't want their name put on a piece of paper. So in that area, there's also 13 businesses. Those businesses are Ann's Crafts, Area Storage, Campers, RV and Trailers, Carolina Casual, Exclusive Countertops, Culligan Water, First Light Storage, Floral Designs, Hot Doggers, Laughing Gull, Lansford Painting, Native Vine, Resort Realty, and It's All Good Thrift and Gift. And out of those businesses that we visited, 14 of them, 12 of them signed the survey. 2 businesses declined. 1 couldn't because it was corporate. So the total businesses that completed the survey were 14, and they were for owners, managers, and employees. So 21 employees, owners, and managers signed the survey. Out of the 21 said they do not oppose to the continued operation of Mermaids at its current location. 21 people said they don't object to the idea of the type of business, and 21 business owners, employees, and managers said they've not experienced any negative secondary effects due to the operation and or existence of the business. And I'd like to point out that several of those businesses are right across the street and right next door to Mermaids.
Does that end the proper, Mr. Plummer?
Yes, sir. It does. And I only have one other follow-up question of the witness for the purpose of this presentation.
From this point on, what Mr. Brown is testifying to may be considered by you as evidence, again, to the extent that it's not objected to.
Even though we did not consider the other information?
That's correct.
Should we question if we have a question about it?
No.
My next question is, if you could explain to the board when you became involved with Mermaids and what efforts have been made to improve the look of the location and the structure, which goes to its impact, value, et cetera, with regards to its condition.
Became involved with Mermaids July of '09. London called me, and I since entered an agreement with him to own 25% of Mermaids. And as part of that, I came down to Currituck County and went before Dan Scanlon and the zoning department with zoning forms and public opinion forms that need to be signed in order to add mixed beverages to the location and the operation. And the zoning official and building inspectors came down, looked the location over, signed the zoning forms for nightclub, bar, had Mermaid's name at the top of it, took the information back to Mr. Scanlon, and Mr. Scanlon then signed off that on those forms that it was a proper location, it was properly zoned, it was a proper business, and it was a proper person. From that point, I went to the sheriff's department and got the adult use permit, provided all the information, fingerprints, did a background check, gave me an adult use permit. At that point, we moved forward with the business stayed open for a little while until we got to a point where we started remodeling the business. We spent several months working on the business, the top floor, bottom floor, new furniture, new carpet. You can't tell from the outside of the building, but we spent $240,000 down here working on Mermaids improvements. After spending those 7 months to do that, we put up a sign that we were debating whether to change the sign to headlights or not, and so we changed the trade name to headlights. Opened up on April 15th, and I was shocked and surprised to see the county officials coming down to the business and handing me paperwork saying we weren't properly zoned, not in the right location, didn't have a use permit. And that very day, I drove straight to the county and presented Mr. Woody with all the information that I had gotten signed off on by the zoning official, by the county manager, and had stated to him that had I walked in the office and the county manager or somebody would have said, hey, this place is not is not zoned properly. You can't get an ABC permit here. You can't operate there. Since I've been involved in this, I can see there's a lot of attention has been put on mermaids in the past. And I would have expected that if I marched into the county, to the zoning department, and the county manager's office, and the fire department, and the building inspector, that they met me on site, that somebody would have said, hey, you can't do this. This is the wrong zone. This is the wrong business. This is the wrong location. But I was told differently. And I have all the forms signed off stating that. Including the adult use permit with sexual and business license, which has been given to the business from the sheriff's department for that address for the last 6 years. So I don't know at what point I was supposed to know not to continue
Mr. Brown,
remodeling with my
interrupt you
operations
here.
out there.
Mr. Fleming, I think that you presented that Mr.
Thanks.
Brown would be testifying as a secondary impacts as opposed to what appears to now be a latches defense, which of course is not appropriate or applicable in a special use permit application hearing.
I would say that I think we're finished with our presentation. He covered the information about the $240,000, which I was, that was the question pertaining to the improvements at that location. Beyond that, I think he's ready for any question that the board would have.
And I guess I would move to strike the non-relevant testimony and rather than go through a lengthy cross-examination, whether you would agree to the striking of evidence not related to secondary impact.
It's an interesting way to do it. I will agree that information beyond the work done, performed at the site would not be applicable for the board's consideration of a special use permit, if that makes sense.
Fair enough. All right, is there any questions the board has for Mr. Brown related to secondary impacts?
So in layman's language, nothing that he discussed about applying for
About
permits.
receiving any permits or who he spoke to at the county, none of that would be for you to consider.
I have no. You have any questions?
I have one,
Yes, sir.
I guess, regarded to public safety impact. It's my understanding you operate other clubs under the name Headlights.
Sure do.
Do you ever have any incidents where, maybe people get out of hand, mix things up a bit?
It's at any business that sells alcohol, you're going to have that problem. It's going to happen. In gentlemen's clubs, generally less than regular bars, and I have regular bars. I own Levels downtown in Elizabeth City. Girlfriends, boyfriends, dating new people, see each other in there. That's where we usually have a problem. We have our problems, but not like regular bars.
Any at this particular location during the time you're operating?
This location,
He hasn't operated it. He hasn't operated this business.
in the 9 days that we were open, we did not have any trouble.
Okay, Elizabeth City, though, you did, no?
Yes, if you're referring to the Blackwater guys, yeah, we did have an incident there.
Yeah,
and
we all read
that
about
incident was the sheriffs and the police department told the people that were involved it was an incident between the 6 Special Forces guys, not Headlights. So we were backed up on that.
Okay, but you say any business of this nature would typically expect to have that sort of secondary impact.
No, a business of this nature would have a lot less. Any business that has alcohol, that's a bar, is going to have more problems than a gentleman's club will. And that's proven across the board with all the gold clubs. And you take a gold club and then you take Thumpers downtown, you know, it's going to be a different story. They're going to have a lot more fights and problems than a gentleman's club, more laid back.
Any further questions for Mr. Brown? All right, Mr. Plumlee, you have any further witness?
No, sir. Here, you have a seat. I think there are others.
Sorry, I got long-winded.
There are others who have signed up to speak, I think, in support as well as in opposition. And I don't think this is the time for me to bring them up to question them, but if they would like, I guess it may be the time for those folks to come up and appear before the the board, but I don't have
Do you
additional.
have anything further for your case? I guess I'll put it that way.
I don't have specific witnesses for my case. I would like to give some summary
Yes.
at the appropriate time.
Certainly. Okay. All right, we're now going to open up the opportunity for those, first of all, in favor of this application to present testimony, and then those who are in opposition to this application. As stated during the opening of this hearing, we ask that you please keep your comments to 3 minutes and please make sure that your comments are relevant to this application and the issue pending before the Board of Commissioners. With that, I will call, and I'm sorry I can't really read the writing. Your first initial is G, and your second initial is C. Gara.
Ms. Cruikshank?
Oh, Gwen Cruikshank. I'm sorry. Are you in favor? Or are you opposed?
I do believe I'm opposed.
Okay, if you just wait just a minute, we'll get to you. Okay, Michelle. I'm sorry.
Too funny.
Michelle Boutelier. Boutelier, are you in favor or opposed?
Opposed.
Okay. I have a hard time tonight. Robert
Debner?
Bedden, you in favor or opposed?
In favor.
Okay, please come forward. State your name and address for the record.
Thank you. My name is Bob Stebner. I'm General Manager of First Flight Storage, property immediately adjacent to Mermaids. In the 11 years that I've been on the property, we've never had one instance, no problems at all, coming from that particular business. I've never seen a police there. I've never had any trouble on my property stemming from that company being there.
Okay, anybody, board members have any questions for Mr. Stedman?
I have
one. Are you open at night?
Yes, sir.
You're there at
We're
night?
open 24 hours a day.
So somebody's on site 24/7?
Yes.
I believe Mr. Stebner actually resides at the
Yes, I
property,
do.
so
I
you'd
live
be in a
there.
position to see that.
I feel a lot better living on First Flight Storage. I feel a lot better when there is someone there, when I see lights on and there's activity, than I do when there's nothing there at all. That's when I'm more alert to what's going on that side, and I pay more attention. When I see people there, I can just generally walk on and take care of my property.
Do you go over and say hi occasionally and visit?
In 11 years, I've been there 3 times.
Oh.
Ms. Plum, do you have any questions for Mr. Stedman?
I don't.
All right. Thanks, sir.
Thank you.
Teresa McPherson, are you in favor or opposed?
Opposed?
Okay. Ann Armstrong?
I'm in favor.
Okay, if you please come forward. And please state your name and address for the record.
My name is Ann Armstrong. I live at 134 Abaduck, and I own Ann's Crafts, and I'm on the other side of Mermaids, and we have never had any problems. It's been kind of good for me because when people call me and say, "Where's your shop located?" I say, "Right beside Mermaids." "Oh, well, we know where it's at." And I have never had any problems with Mermaids. You can't hear the noise over there. You can't hear music over there. And I think when y'all said that there wasn't going to be any more problems with Mermaids in that year, I think that should have gone on. I think there's too much money been spent on it, and you're spending more money on it, and I think it should have been taken care of.
Okay. Any questions from members of the board for Ms. Armstrong? Mr. Plum, do you have any questions?
Do you not?
All right, thank you.
I got one other thing to say.
Yes, ma'am.
I live very close to Mermaids, too. I have a residence very close.
Thank you. All right, Gwen Cruikshanks.
Thank you, Mr. McCrae. Commissioners, thank you for the opportunity to speak to you about this latest attempt by the Mermaids owner and the Headlights OBX to once again flout the laws of Currituck County. How many times have I stood before you against granting Mermaids a special use permit? Too many times to count. I was here in this very room when Mr. London first applied to the county, and as I look around, I see some of the commissioners, staff, etc. as well. At the time he was asked, "Will you have topless dancers?" Mr. London replied, "No." What does this tell us about the man's integrity and ethics? That he's not to be trusted. Time and time again, the county has ruled against opening this club. I live in Currituck County, and I have to obey the laws and regulations of the county. It's my firm belief that Mr. London and Associates should have to do the same. The UDO clearly states that this type of operation should not be located where Mr. London has chosen to operate. There are other places in the county where he could operate legally. An establishment with topless dancers is not in conformity with the UDO. My community is residential and is comprised of families with small children, senior citizens, and young adults. Clearly, a topless bar does not conform and is not in harmony. Regarding new owners of new homes that have come into the county, present today is one member of our community who bought her property because she was told the county was in the process of closing the Mermaids. Otherwise, she would not have bought. Also, the same individual, Mrs. Collins, has found nude pictures in her backyard.
I would object to hearsay.
Not hearsay, the lady's right here. She preferred not to testify because she's not comfortable speaking in front of people.
To the extent she's not going to testify, then please, Ms. Crookshanks, she shouldn't say what she would say if she did.
Well, excuse me then.
And pardon me, but I would move to strike the information. Thank you.
The purchase of a home is the single largest investment most people make in their lifetimes. Our property values have gone down due to the proximity of the Mermaids. I am concerned about a precedent. Were you to allow one topless bar to come in, you can't obviously deny others. We could easily become the red light district of northeastern North Carolina. This is something I certainly don't want for my county, and I'm sure that the commissioners do not either. We are here tonight to ask you to enforce the laws and regulations of the county and deny the Mermaids' special permit request once and for all, and close them down permanently or until they operate legally. Thank you for your time.
Any questions from Ms. Crookshanks?
Oh.
All right, if not, Mr. Plum, you have any questions?
I do not.
Okay. Michelle Boufflier, I get that wrong again, probably? Yeah, a little bit. Okay, if you please state your name for me and the record.
It's Michelle Boudelier. I live at 128 Acorn Lane. I do live in the neighborhood behind Mermaids. A couple of things that I had questioned is, was there going to be more police activity at a place like this? So I pulled the police record from Headlights in Elizabeth City because I figured that was the closest place. On there,
I would object to the relevance of that information.
well, the reverence was secondary. Well, you can answer that. You're the lawyer.
Since she's testifying to secondary impacts.
Well, and its admissibility as well, based on hearsay and not meeting any known exception.
Yeah, well, yes. You can testify to what you know.
Well,
without relying upon what others have told you.
Okay, so police reports don't matter then?
Yes, ma'am.
Okay.
That's right.
Basically, these places are known for illegal businesses. You have to be blind if you think.
And I would object to what these places are known, and I hate to keep objecting.
We understand your objection, but we understand these are also lay people, members of the public, and we'll.
Absolutely. If I could just put my objection down, and then I'll move on.
Okay. All right. Noted.
We do know that these kind of activities happen in this kind of places. Yes, there's our bachelor parties and bachelorette parties, and I'm sure people go in with fun. But the people who regularly visit these places usually do not have character, values as the families that live in Acorn. We have a lot of small children in that area. We have a lot of families. It was also brought up about the housing, only one house being sold. That house was sold as a short sale. So that cannot be really a sale that you can count when you realize it wasn't sold as a retail. You didn't object to anybody else.
Mr. McCrae, I have a question.
Yes.
Why is it this gentleman was allowed to give hearsay and asked to be brought into the record, but yet this lady is not?
I understand. Mr. Stedman, from what I heard, was given his testimony was based upon what he knew
from his surveys.
Oh, you're talking about Mr. Brown?
Yes. Why was he allowed?
That was not evidence that you
It was
were to
proper.
consider.
Yeah, we didn't hear that.
That was just, it's just as if you didn't hear that. That's just a matter of creating a record should this matter go forward.
Nonetheless, you allowed it to be said, and this witness has police records.
To the extent that you would like to make a proffer, then that will be fine. Again, to the extent that it would be hearsay, you cannot consider it, but to the extent that we want to see if a judge would allow it, if it goes forward, then that will be fine.
Proceed.
For the purposes of, and I know it's just technical, but for other purposes, go right ahead. Say what you have to say.
Okay, with the police report or without the
Yes, ma'am, go ahead.
On there was incidents of papers served, fights, solicitation, fights again, indecent exposure, and basically 3 pages of those, 4 pages. So there are police that go to headlights. I'm not, like I said, this is just not a business that we want in our neighborhood. If you look around the surrounding areas, that is a lot of land that can be valued for more real residential property. The lot in the back of Acorn is already for sale, and I'm sure when the economy is better, that will probably be one of the most beautiful spots to build a new house, especially when it's around the sound. And what will harm it would be topless bar. That's all I have to say.
Thank you very much. Any questions from the board? All right, Ms. Plum, any questions?
No questions.
Teresa McPherson? Will you please state your name and address for the record?
Teresa McPherson, 117 Evans Drive, Grandy, North Carolina. My first question is that when Mr. London came up to give his testimony, he was told to state his name and address. He did not do so. He stated his name. I'd like to know his address.
Mr. Brown. Mr. Brown.
Brown, excuse me.
Yeah. Well, I mean, he's not responding to questions, I guess. But
He can do that at the next opportunity.
Sure, we'll do that.
Okay.
The next thing is I would like to echo the sentiment. This is not in conformity with the UDO. Quite frankly, at the risk of sounding like I'm chastising this board, I'm shocked. I don't understand how this has taken place for 17 years. I don't understand. And perhaps it's because I've not been involved. I've not lived here for that long, but I've not been involved, and so I have little understanding of it. But quite frankly, from a layperson's point of view, this should not have gone on. So I would like to know how that is. The next thing is that this type of business is very damaging to young women. It entraps them in a lifestyle.
I object to that type of testimony, and if the board wants to
For the
hear
purposes that you want to proffer, as you've heard us say, Ms. McPherson, go ahead. From this point on, it'll be for proffer.
Thank you. This business entraps young women in a lifestyle. It entices them for the benefit of income that a very depressed community needs. And I find that to be appalling. And I think that if you vote your conscience and if you consider all of the facts, that there's no way this business should open up or continue. I believe it should close down, quite frankly. Thank you.
Any questions from Ms. McPherson from the members of the board?
Anyone have a question? I'm going to call a 5-minute recess. Declare a spike in order.
As we begin again, I think we want to get Ms. Cruikshanks. Can we get your name and address for the record? I don't think we got that. And then Mr. Plumley, Mr. Brown, if we could have his name and address for the record as well.
110 Acorn Lane, Point Harbor, North Carolina, Old Oak Estates.
Thank you.
Mr. Brown is 1428 North George Washington Highway in Portsmouth, Virginia.
Okay, thank you. All right. Ms. Plumley, if there's nothing further for you to present, that ends the list of persons that wish to present any statements or testimony. And so now it's to you for any rebuttal evidence. But I believe you told me you don't have. And then if you're ready for argument, go ahead.
That's correct, Mr. McCree. We're not presenting rebuttal evidence. We believe the evidence we've presented is sufficient to establish that there are no secondary impacts as a result of this operation. And one of the questions raised by the commissioners during the meeting is why consider beyond 2000, because the application was 2000, and what I believe is important with regards to secondary impacts is to look at actual impacts during that period. And I don't believe I've heard anything with regards to an incident at this location that's cause for any concern that's anyone's come forward. With regards to those folks opposing this, I believe they're going to oppose it whether or not there is in fact any real secondary impact at all, because they oppose the nature of the business, not what's occurring at this specific location and has occurred over the years that it's operated, like we have said. And it's in compliance with the presentation by Mr. Woody. This has been going on there for 17 years, so there would have been plenty of opportunity for negative impacts to have developed to show themselves. Ms. Berry did present evidence demonstrating that the value through the market analysis has not decreased as a result of this business. There does not appear to be a drop in value as you move south towards this business. And because of the very few transactions that occurred in this area, that is the most valid analysis to be conducted by a qualified real estate appraiser in this area, as opposed to comparable sales. So we've presented that to the Board of Commissioners, and we also put forward, while we have conceded that we're within the 1,000 feet, we are considering 1,000 feet, just to be clear, because it was my understanding, and you can correct me, Mr. Woody or Mr. McCree, that there was an increase in the buffer to 1,500, but this is looking at 808, which is 1,000 feet, not the most recent iteration, which I believe moved to 1,500, but I may be...
That's correct. 1,000 feet is a basis.
Okay. So we do concede that there is a residence or an R zone within the 1,000 feet, and that this is general business and not heavy manufacturing. However, through the board's authority under 1.7.1 F18, we ask the board to consider the extraordinary circumstance of the operation of this business, that it issue a special use permit, that it attach any conditions it believes necessary to keep the business in compliance and harmony with the residents and the businesses located within this area. And that's in essence my case here. This has not been taken to planning since 2000, so it did not have a chance to comment or look at secondary impacts to present to the Board of Commissioners. But for these reasons, we ask the board to issue the special use permit, finding the application complete, finding that there are no negative secondary impacts, that in fact, while there may be residences within 1,000 feet or are within 1,000 feet, and that it's not heavy industrial, it has been operating without incident for 17 years, taking that in consideration under the board's authority. Thank you.
Mr. McCree, can we ask Mr. Plumley a question?
You certainly may ask questions of him. Of course, what he's saying to you is argumentative. Obviously, it's not as testimony or evidence.
A couple of questions. To your knowledge, has your client ever applied for rezoning of this property?
No.
But
And
he
I
has
think we
had the
conceded that.
opportunity.
Has he had the opportunity?
Yes.
I can't comment as to whether he's had the opportunity. I haven't explored that question specifically with my client concerning his opportunity to apply. Obviously, the board can take under consideration what it believes to be fair opportunity of my client, but I can comment that he has not applied for rezoning at that location.
To your knowledge, has Currituck County ever applied that special section you just stated to grant a special use permit outside of a zone that it's designated for?
That's not. I have not had that experience. No, sir. I don't know of an instance, though I can't say I've done significant research into that question.
I've been around here for a long time. I don't ever remember it being done.
And Mr. McCree may have some thoughts along those lines as well, but my what I can tell you is I have not researched whether this board has applied that section in this manner.
Could you give me that section again, please?
Matter of fact, Mr. McCree, I'd like for him to read it to me because I'm not following him with that section.
This is section 1.7.1. The Board of Commissioners may not attach additional conditions that modify or alter the specific requirements set forth in this ordinance unless the development in question presents extraordinary circumstances that justify the variation from the specified requirements.
So what are your extraordinary conditions?
That we have operated this location for 17 years without incident.
But in fact, you say your client, you're actually representing two clients, are you not, Mr. London and Mr. Brown?
No, sir. I represent both gentlemen in their ownership of this business entity.
All right. Well, the testimony that Mr. Brown gave was exact as a discussion he had with me in my establishment. He came into here, he went into business with Mr. London as a 25% partner. He came to the county and applied for permits for a mixed beverage license. But he had no knowledge that Mr. London did not have a permit to operate a topless establishment. And he stated that to me. He knew that to me as he stated right here. He did not know that. So you're actually operating under two different individuals, a 25% owner and a 75% owner, and the 25% owner has testified that he's invested $250,000 in this building and he wants to get out of it. That's the way that I see it.
Maybe we can clarify for the record. Now, RF London Incorporated is the applicant here.
That's correct, and all rights have passed from RF London Incorporated to Mermaids Incorporated. The shared ownership's in Mermaids Incorporated, and that's how both gentlemen own a share of this business.
Mr. Chairman, I have one question.
Yes, sir.
After 2006, did Mr. London ever come to the county and apply for a permit for an adult establishment?
No, sir. Not that I'm aware. I don't believe there's ever been an application for rezoning, if that's the question of the board.
Not rezoning.
Say that.
Special use permit for an adult establishment.
That happened in 2000, not since 2006, sir. Which I believe was your question, since 2006.
That's exactly what my question was.
I'd like to kind of clarify that timeline too, if I could. When exactly did he begin operating an adult establishment?
1994.
And when did he apply for a permit to operate an adult establishment?
I believe the application was deemed completed in February of 2000.
Oh, that seems like an extraordinary circumstance to me.
I have a question. Will you concede that there never has been a permit for an adult-oriented business?
You're talking about a permit directly issued? No, I will not concede that, because by dismissing the suit in 2006, it will be our legal position that this board issued a permit for the operation of this business.
If the suit was dismissed, why are we here tonight?
The suit was to be dismissed, and that was a ministerial function of the attorney representing the county at that time. I believe the attorney was Ms. McKenzie. Ms. McKenzie stated that we'll have to file claims to dismiss, and it's in the transcript that's provided, her terminology, so you don't have to trust my memory exactly. But in her terminology, she was going to have to get the claims dismissed. One part of it was to go to the Board of Adjustments to get theirs dismissed. That work was not done by the county. That does not mean that the dismissal wasn't deemed effective as a direction of the Board of Commissioners at that point. From a legal position, that's my argument.
And
Go
ahead.
Can a defendant dismiss a lawsuit?
This is an appeal from this board's ruling on a special use permit. While it cannot necessarily dismiss it on its own, it can proceed by issuing paper sufficient to cause the dismissal, and that was not done.
Shouldn't have Mr. London applied for the dismissal?
Well, no, I think it's going to have to be the board that initiates that, because Mr. London does not want to lose his appeal position by submitting a dismissal and having the board shift at that point. And so he's relying on what the board's actions were.
So you're...
I'm sorry, I was just going to say, I didn't know defendants could, because there'd be lawsuits dismissed all over the country if they could.
Well, the question I think we're addressing tonight is not really what the court might do, but this special use application.
That's right. Does the applicant's application meet the requirements of the Unified Development Ordinance for issuance of a
I think
special
we
use
should call
permit?
that question when
I only commented because you asked if we would concede that point, and I won't for that reason concede that point. And that's, are there any more questions for me?
Well, the reason I asked that question is you're contending that you're operating with legal permits. And I can find no record where legal permits have ever been issued. And I can find no record where this case was dismissed. And I don't believe you can show me a record where this case was dismissed. I would like to see that record. Could you produce that?
We have presented the transcript of this board's proceeding. That's our record. There's nothing in addition to that I have, if that's what you're asking.
You are aware that a previous board cannot bind a future board.
No, I'm not, sir.
So there is no record.
I've presented the transcript, so that's our record.
That's it for me, Mr. McCree.
All right, Mr. Chairman, I think it'd be appropriate now then to close the evidentiary phase of the hearing. If there's nothing further, it will now be up to the board to deliberate and make a decision.
Well, I'll close the public hearing and ask the board for a motion.
Motion for denial.
Have a motion for denial, a second.
If you want to base that, you want to make sure that you make
Yes,
the
findings of
respective
fact.
findings, or at least refer to those that have been proposed by staff.
Please
If that's
restate your
intention.
motion.
Based on the findings of facts and the staff's recommendation, I make a motion for denial.
I have a motion for denial. I have a second. Any discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Opposed, no. Motion carries. Item 4, consent agenda.
Move for approval.
Have a motion for approval.
Second.
All those in favor signify by saying aye.
Aye.
Opposed, like sign. We'll wait just a minute. We'll go to Commissioner's report. All right, Commissioner's report. Ms. Taylor, you have anything tonight?
No, but we have, with the fellow commissioner, we've been all over the county in the past 2 weeks, and 2 weeks left to go. But I do want to remind everybody about what Troy Breathwaite said today about the No OLF meeting, Thursday, October 28th at 7 p.m. at the Moyock Library.
Thank you. Mr. Nelms?
Yes, I'd like to commend the folks in Walnut Island for their effort to clean up the county. And I want to congratulate them. They worked very, very hard. The community, as they've stated, has worked to see that this is done. Also, again, to thank the VFW. I rode down there myself day before yesterday with my wife, and there was an extremely large crowd, and we sent a lot of people down there from the restaurant. We had people from all over that were Vietnam vets. And it's a great thing that they've done. It looks like they've started a tradition here in Currituck County of bringing this wall there. And as Mr. Gregory said, it's very moving.
Mr. Rohr?
Yes, one thing I'd like to mention. Last weekend, Commissioner Etheridge and I had the privilege of participating in the awarding of the Chris Gracious Make-A-Wish Foundation, a special award to Dennis Anderson, gravedigger down there, because of the many wishes he's granted to kids all over the country through his operation down there. We had a tour of the operation, heard a lot of the stories about this. Absolutely heartwarming, very, very moving. And I just want everybody in Currituck County to realize how much of an ambassador for Currituck County that Dennis Anderson really is. Oftentimes, because he's a native of this area, we don't recognize that sort of thing. But the international front certainly knows him. He certainly gets the word about not only his own operation, but where he comes from out. And I just think it's extraordinary that we have somebody like that here in the community, and we certainly should recognize that.
Thank you. Mr. Idlet?
I totally agree with Mr. Rohr's comments. I was at that function as well, and it was a very nice function. That's all.
Mr. Etheridge?
Ditto on Dennis Anderson's award. I believe it was said that he is an entertainer, and the greatest gift an entertainer can have is putting a smile on the face of a child that is in a desperate situation from a medical standpoint, and that's exactly what he does. And I expect that we'll be seeing bigger and better things out of Dennis and what he's trying to do down there. I was in Wrightsville Beach this past weekend at the North Carolina Association of County Commissioners State Board of Directors meeting. And I'm going to be preparing a report for each one of you, but bottom line, there was a lot of discussion on the state budget for next year. That's already $3.2 billion in the hole, and some of the concerns and worries that might be taking place for if the state is to balance this budget as they have in the past on the backs of the counties in a lot of instances.
Mr. Gregory?
Chairman, I would also put a plug in for Dennis. You know, when people ask you where you're from now, you say Currituck, and they don't recognize it. You say, "Down there where the Gravedigger's at." Everybody knows where you're from, but he's really brought recognition to our county as well as overseas too. But I would also mention the Bark in the Park that they had Saturday. That was an overwhelming turnout. I mean, it was 5 or 6 rows of cars all the way back to the highway parked up, and they had to run shuttles back and forth. But they're going to have to move to bigger headquarters next year. They're going to have to get down to the high school or somewhere, I think. But that was just an amazing turnout they had, and everything's good.
Anything else? Well, first of all, I want to thank Mr. Etheridge for the time he puts in with the Association of County Commissioners trying to beat back what the state could do to the counties and the local governments as it goes forward. And I also want to recognize Mr. Nelms, who served as the chairman of the Albemarle Commission. I believe y'all had your meeting for the whole state over here on the Outer Banks, and I understand it was really nice and got a lot of accolades from the job you've done and the accommodations and everything that was done, and congratulate you on that as well. We got some folks we kind of get out throughout the area. Mr. Gregory's on the health board, does a lot of work, and Mr. Idlet on the Whalehead Trust, and Mr. Rohr on the ED board and airport board, and Ms. Taylor on the senior citizens board. So everybody, and then staff, and the fire advisory boards. So the commissioners they're out and about and a lot of things other than just sitting up here. I mean, you could be gone every night if you wanted to, or you had the stamina to, and staff as well. So I just want to tell you, as my tenure is coming up to the end as chairman, I just want to tell all of you thanks for all you do, and Miss Keene for being at the meetings to take the minutes, and Mr. Woody, and all over the place. So I just want to thank all of y'all for what you've been doing this past year and the service, and recognize it. So with that, Mr. Scanlon, you have any
Yes, sir. I'd like to report back to the board at our last commissioners meeting. We talked about, or the board talked about, the staff showing flexibility with citizens that might have had hurricane damage or storm damage from Tropical Storm Nicole. The staff was directed to talk to CAMA to see if they would follow suit. And I'd like to report back to the Board of Commissioners that we do have a response back from CAMA. The fees assessed by CAMA are set at the state level by the General Assembly. Therefore, at the local office, they do not have the authority locally to waive those fees. There is a procedure under an emergency general permit that is required to be issued and authorized by the Secretary of the Department. It requires that permit for them to be able to waive fees, and to date, that permit has not been issued. As a follow-up to that, though, Commissioner Gregory had talked to me this morning. There was an article recently in I guess several of our local papers about areas being declared disaster areas by FEMA. There is some public assistance and individual assistance that is available. So if anybody is watching this or needs information, they certainly can go to our website. This information will be posted on our website. They certainly can call my office for further information. But we have a contact with North Carolina Emergency Management. We have a telephone number for them that if individuals have experienced some kind of damage or loss to their house and they need repair or replacement, or protective measures being done. There is some public assistance available or FEMA assistance available for that. There is a question whether that assistance extends to docks and piers. The information we were told today, it depends. It depends on how the dock and pier is used and how integral it is to the function of the primary residence. But they did recommend that you don't know until you apply. So we certainly want to encourage anybody that feels like they need assistance. Again, if they would look at our website or call my office, we'll make sure that information is readily available to them. There is an application process they would have to go through. That's it.
I have one last quick thing. I got a phone call. The board asked the Marine Fisheries and Wildlife Resources Commission to move a sign where they had moved a sign out and blocked some of the local fishermen from using a creek up in the North River. And Mr. McCree, I called him today to follow up on it, and we might need to, I don't know what we need to do, but they have not made the move yet to put the sign back where it was. So
Well, we had good success, as you know, with marine fisheries on the turtle issue and
Right.
reopening our waters to fishermen with gill nets. And during the course of that time, I was talking to Dr. Daniel, who's the director of marine fisheries, about that North River issue as well. He seemed to believe at that point in time that it probably really was a Wildlife Resources Commission issue within their jurisdiction, and that they were going to be meeting the two staffs together, which evidently they meet regularly to discuss common interests or concerns and talk about who needed to take that lead and then what could be done. I think that the county manager has spoken with Gordon Myers, the executive director of the Wildlife Resources Commission, and I will follow up after talking with the chairman today, because nothing yet has been done to see what the status is and when we can expect some resolution. I know at one point there was discussion from the state agencies that it may require a rule change, which could take up to a year or more in order to implement a rule change for whatever reason, particularly when the sign's been in that location, so we understand, for 50 years. But we certainly will follow up with Wildlife Resources Commission and try to find out what's going on. And certainly if we need this board to enact its muscle, we'll come back to you and look for that as well. But we'll try from the staff level to do what we can in the meantime.
Okay.
Mr. Chairman, if I may, one of the things that we talked about this weekend is exactly what you and Mr. Scanlon just touched on. State agencies interfering with timely processing of permits and whatnot, and it slows down economic development. And the governor has a commission that is looking at situations exactly like this. So this might be two that we could take forward and show as examples, that because there's such redundancy and overlap of agencies, and if we really want to cut the state budget, that's where we need to do it.
Yes, sir.
Dan, where are we at on the resolution for the sound study? I haven't seen anything come out yet. Have we passed our last meeting?
That is being drafted.
I've got contacts in with the agency representatives from the Army Corps of Engineers and from NC Diener, and I'm waiting for a response back from them. So I'll follow up again tomorrow.
Just to let everyone know, I got the meeting set up between some of the historical knowledgeable people in the Sound. It's going to take place here next Monday. Mr. Booty Spruill is going to participate. Mr. Joe Luar from Knights Island. Mr. Jim Clark has found all the research and studies that were done up in the Back Bay watershed in years past. The project manager from the Corps of Engineers will be here, and I'll come as well, and hopefully we can get them all together and get some data put together.
All right. Anything else?
So, Shawboro Rowton Club having their prime dinner Saturday night from 4 to 7.
You buy it.
Come on.
All right. Have a motion to adjourn. Second. All in favor, aye.
Aye.